Yo, yo, no voices. All right,
Peace,
Hello.
y'all can
peace,
hear me now, right?
loud and clear.
All right.
Yeah.
All righty, we in the game now. I know everybody can hear me now for sure. So, drop your ones in here.
We can't, not in.
Y'all ain't on here. Y'all got to be out here with me on the other channels. You get to hear the music and everything. They don't know nothing about that, do they? Anyway, though, guys, welcome to In God We Trust Academy and the Lawman podcast. This is episode 3 today. So thankful to everyone and your participation as always. And, everything is just been beautiful, man. Taking this journey day by day, willing to learn, willing to experience, willing to, be. And all praise to the Almighty for that as well. We got a few more minutes before we get started. We had a few technical difficulties, but we are live and direct, so everybody should be able to hear me from all platforms. Y'all can hear me on the other platform. Those of y'all watching here with me. Yeah, no, maybe, who knows? Somebody said, I remember when you first started awakening people. Wow, that's been around for a minute. Grand Rising. What's happening, beautiful people? Wake up. Wake up. Wake up. I just want to say, man, last night was amazing. If you was there last night, it was amazing, wasn't it? Had to be there, though.
Powerful.
I was definitely fulfilled myself. Just being able to speak in those words, and it's very enlightening, but also It's liberation. It's revolution within itself. It's also revelation within itself, and it was beautiful. So if you missed it, it's still up. You might need to go check it out. How many y'all was there? What was y'all thoughts? Now that we got y'all on here.
It was amazing, man. I went through and I was writing down each and every scripture that you had down so I could go deeper into them in each and every one of them. But I ain't finished. I ain't finished because I always try to go through them twice and 3 times every time we do a class, just to try to capture the most I can out of it.
Oh
But it
yeah.
was a powerful thing. It was a spiritual thing. I appreciate you, man. You a blessing, man, for real.
Appreciate you, brother. Anybody else, man? You're more than welcome to speak.
I thought it was really, I don't know, just meaningful in terms of like the holiday and the meaning of what we're doing and how it relates to Easter and Jesus and the law. Just it really kind of, yeah, just like my church. So thank you.
You're welcome. Welcome, welcome. Anybody else? Anybody else? For me, I'm gonna say because even putting that together, I just sit back and I thought about like this whole entire time of being raised by a pastor, being raised by men of what people consider men of God. And um, none of them could ever explain it to me how we all just received and then it was explained yesterday. It's never, ever. And then I look at, certain things and it's like, do we really know? Did we really know? And a lot of people feel like if you don't show up to a building, if you don't show up to a building to pay them tithes, or if you don't show up to, I don't know, be in somebody's church, as they say, that there's no basically salvation for you. And it's just like, last night put the nail in the coffin on a lot of different things and stuff because, like I say, we've been in the church, we still ain't healed. We've been praising, we've been paying tithes, we've been doing a lot of stuff, and the people are still lawless. They still not healed. They still remain without justice. They still remain without in the absence of God. Do y'all understand that?
Yep, every day too.
So God said that you, the people in here right now, that you are the people whom he spoke about that will pick up the law again and that you will rise up, right? And that you will turn from your wicked ways and you will begin to know God because you accept authority, because you accept salvation, justice, truth. As we discovered, truth is the only religion, guys. Truth is the only religion. And that's it. Because no matter what, everybody, in some shape, form, or fashion in your life, you want what? Truth. Truth is universal. Truth is something that we all seek in every measure of life in this human form, right? So with that being said, truth is the kin to justice. Truth is the kin to law itself. And that's the way that justice prevails. That's the way that the law prevails. That's the way that God prevails, etc. Is through truth at all times. And that is the study of what we do here and what we're supposed to be in place of. So I just want to say, man, last night was really dope. So I appreciate everybody that was tuned in with me. Y'all stayed the whole 2 hours and something. But y'all know how we get down. We're probably gonna do 2 hours and something today. But it is, that's how we get down. And it's really powerful to have people, willing. And I see y'all. For real. I see y'all. Because y'all here every time. Every time we on here, y'all here. And y'all still moving. You actually studying, you applying it. So you should really feel good about what you heard last night, to understand that you really on the right side, to understand that you really are, receiving salvation by doing what you're doing right now. You understand what I'm saying? You got to know that you really are. You ain't never got to question if you gonna make it to heaven. You on your way right now, doing what you're doing. You're gonna get to experience it right here on earth too. You're gonna have you're gonna become prosperous. You're gonna see prosperity. You're gonna see success. You're gonna see it all by doing exactly what you guys are in here doing now. Don't forget that. Do not forget that. All right, so we do have the class coming up. All right. And the class that we do got coming up, well, the conference. The big conference is June the 27th. We will be in Atlanta, Georgia, June the 27th. All right. God's Law, My Salvation. It comes with four great ebooks will be in this. But again, as I always say, if you not about what we talked about last night, if you're not about really picking this up and correcting yourself and studying and doing this every day, then we don't need you. We don't need the time. We don't need the energy. We don't want your money. We don't want nothing. It's really that's what it is. We don't need to tie any type of energy that is going to transgress against what we're doing. So make sure that we bring those who really truly seek in that order. Choose to correct yourself. You're looking for where to start, how to start. What is it that you need to know when it pertains to your rights, how to exercise your rights, how to raise your issues and defenses, or when it comes to your rights, how to stay in your majority status, because you are already in the majority status as long as you are of legal age of 18. All right? It's when you show that you don't know is when you fall to minority status. So I'm going to show you how to keep your majority status, because God said you was golden already. So nobody can take that. So, but the only way that you stay and remain in that is that you have to do what, family? Study the law daily. That's where all judgment can be made righteous, is through that. So make sure June the 7th, it will be 5 hours, 125 in person and 100 for live stream itself. You got me for 5 hours. All right. And I tell people this all the time. Listen, if you got the time and you're not in something serious, then June the 27th is the day you need to be there instead of trying to pay me $100 for 30 minutes to talk. You need to be ahead of it, not wait until something happens. And now you got 5 hours of my time, plus all of the information that I have that's going to show you. So you're getting 11 years of information from me to keep you from going through all the shit I went through. Because people said this or people said that. And, you know, if you go chasing process, if you go chasing a template, you're never going to know. Because what that means is you're not going to be able to walk in and exercise what needs to happen when something comes and take place against you, right? So, hey, you can cite a code. People cite codes. It's a lot of citing codes. It's a lot of posting case laws. It's a lot of that going on. But when it comes down to the actions and getting ready to operate in procedure, people do what? That's what people fail at, right? And we all been watching. Which way to go? Which way to go? And God said, hey, my word is written publicly. You don't got to listen to the Pharisees. You ain't got to go listen to none of these people out here talking. Come straight to me. Time plus consistency equals growth. Study the law every single day, and you're going to grow within it every day. Don't let up off of it. Make it your daily bread. You have to. Man cannot live off bread and water alone. He has to learn to live off the what? The law. Because if he does not, you become what? Self-destruction. Self-destruction is what's exactly going to happen to you. And it's proven every day. All right. Just know this. You got a chance to get two raffle tickets here, right? And we're still giving away the card June the actual 20th, 2026. We are going to do a giveaway. We're going to do it live on live stream. So, you know, from what I see, everybody's not in the traveling mood at that particular time because y'all going to be trying to come to Georgia. So, cool. Come to Georgia then. But we're going to give this away live, and whoever wins this car, whoever wins the cash prizes, et cetera, we can definitely get the cash prizes. But whoever wins this car, you're going to be responsible for coming to get your car. Nah, I'm telling you now. You better get your buddies gas up and come get a brand new car is what you need to do. All right, I don't care how you do it, but you're going to be responsible for coming to get it. All right, we still got a few more months, right? So the donations is 10 per ticket as well. If you want to be involved with that, you're more than welcome. Now, let me show you something else, though, because you can get 2 of those tickets and you automatically get a free ebook of your choice, such as Unlawful Repossession Handbook and the Declaratory Judgment, which we're going over today, is also in there. And then there's like 4 to 5 others that's in there as well, too. So do know it's only just 2 raffle tickets at that particular time to get one of those. So ask, if you get 2 raffle tickets, say, hey, what ebooks are available to me? You see, and they will be, you'll get to choose which whenever you want. If you get 6, you get 3, so on and so on, right? Totally up to you. All right. And don't forget about joining our private group, In God We Trust Academy, on Facebook. Make sure you join us there. We are right now in the Fair Credit Reporting series. And basically where we're going to just teach you that whole entire law that deals with that particular area. And that is because why? You out here letting everybody judge you off your credit. So you remember, your duty is to govern too. You have to govern them, and this is the law that you're going to use to govern them. That's your duty. Everybody say, oh, I'm sorry. Okay, pick up the law and govern. That's all you got to do. You're sovereign. Okay, I get it. We hear you. Pick up the law then and govern. Use the Fair Credit Reporting Act and govern them. Use the Fair Debt Collection Practice Act and govern them. Use the Truth in Lending Act and govern them. Use the Constitution and govern them. Use their statutes and govern them. Sovereigns. That's all you got to do. I hear you. We hear y'all, though. I promise you, we hear you loud and clear. But when you come in there and you start speaking to stuff that don't match with law and we do not see you. We do not hear you. We do not know you. Who are you? What authority do you have to even come here in this court and speak these things? How dare you? What's your name? Oh, you're not such and such? Oh, so John H. Doe is not here. Who are you? I'm not the name. Okay, we got you, but who are you? Why are you here? Put a warrant out for John H. Doe. And there you go. Because you chose to cite something that didn't have nothing to do with the law. When all you had to do was challenge what? What y'all supposed to challenge? If you're going to say something about the name specifically, then now you're trying to say personal jurisdiction, right? It's the only thing you can do. So you still saying the same thing, but you got to know how to do what you're saying. It's personal. So make sure we know that. Make sure I see y'all in the class. No excuses, right? We're still putting trust together. Everybody that I am doing a trust for, you should be receiving everything today. Got all y'all knocked out the way. Home run. But this is the ebook as well. The Lawman Resurrection of Justice that we went over. You can give any donation that you want. I don't care if it's $1, $2, whatever, and we'll send you this ebook if you're interested. So just know it's up according to your donation. To other people that already have donated, special thanks for sure, especially you, Jennifer Shields. That was amazing. So definitely appreciate you. I would definitely say that. So I see people, that people that choose and truly do value us, and you definitely are one of those that do. So appreciate you and thanks.
Thank you, Eric.
Surety ship. So we got surety ship April the 27th, the 28th, 29th, May the 1st, and May the 2nd. That's 5 days, 5 classes. All right, 5 days, 5 classes. They probably going to be about 2 hours a piece, so we going to get 10 hours in probably. So you know what I'm saying? It's going to be 10 hours. If you can't make it, that's cool. You will still get the recording to go over yourself. We got 5 ebooks to go over. The sixth ebook is templates. I'm going to leave that to you. I'm not even gonna go over the templates because I feel like I'm gonna make sure you learn it anyway. So if that means we gotta take these days and read, and I'm gonna make sure you read because you was here, you heard, then you can do the templates by yourself because now you got an understanding of what they mean. How does that sound? I think everybody be all right with that. Because I'm here to make sure you know it, you learn it. Not you picked up a template and then you got to turn around and come back to me and say, what do I do? I gave you an ebook that explained what to do. Did you read it? No, I did not. I just took the templates. And I get that all the time. And I'll be like, are you for real? So you thought you could just turn back around and say, what do I do? And I was like, bro, I literally told you what to do through the ebook. If you read it, it explains it. Not jump straight to the template and now you got to ask what to do when it's right in front of you. That's why we got to go read what, guys? Joshua 1 and 8. Joshua 1 and 8. So those 5 days are going to be great.
Should we be seeing your screen?
Nah, y'all ain't seeing my screen right now. I'm going to let y'all know when to see my screen. But do you want to see it? I'll let you see it. She like, we usually see the screen in here now. We ain't getting it today. Something up. Y'all good now. Greetings. How do I get a consultation with you? InGodWeTrustAcademy.com. InGodWeTrustAcademy.com. That's how. It's on my website. All right, so let's hit this record button. We're going to record this one, the declaratory judgment, because I need this. And, of course, got something to ask you guys up in here today. Do anybody, and I mean anybody, got a testimony? Did you?
I have a testimony.
Oh, I know that's real the way that sound now. This got a little fire behind it.
Oh yeah, the perfect storm, baby. The perfect storm.
I'm ready. Are y'all ready to hear this testimony, man? I need to know now, cause the way she just
Please
came.
and thank
Y'all
you.
ready?
We sure are.
Tabernacle.
Okay, now
Okay.
we ready
I'm
now.
gonna need y'all to take some serious notes, and I'm gonna give y'all some tea.
Oh, okay. I'm ready.
Okay.
Let's go.
So first and foremost, I haven't been on these calls in a while because I've been studying these laws here in Illinois. First and foremost, I am the lady who had a trucking company. They had an insurance policy where the big insurance company failed to send my annual update to the FMCSA, and they basically shut my company down for like 3 weeks until my insurance company put it back on the books with the Federal Motor Carrier Safety Administration. Okay, I lost all of my contracts, y'all.
Mm.
Every last one. I had railroad contracts. I had contracts with Pepsi, Coke. The people who do the bottles for Starbucks, like I lost a lot because no no company will wants to work for a freshly newly not
Oh,
incorporated but
you had to start
insured
over.
trucking company. So my authority went back to day number one. And I had
Dang.
2 years worth of authority history. But when they failed to update their policy, their annual update, when my policy renewed, I lost everything. With that being said, I'm very strategic and I was very patient. A year passed and they still didn't want to settle my claim because I would not sign off on the stipulation to take all of my employees' rights, my contractors' rights, my heirs, who I'm building this company for, right? My heirs, okay? I ain't doing this just for fun. I want my family to have a future in this business, and they ruined that all. So I played the game with them, and for a whole year, we were emailing back and forth, and they raised the price up to $10,000 to settle the claim. I said, no way. not my hard-earned labor, work, knowledge accumulating in this field. I'm not selling it for $10,000. And I damn sure ain't selling out my employees for $10,000 because they ain't getting none of that. And let's just be honest. They need to be compensated as well. With that being said, they mustered up and they sent me a whole letter taking fault and admitting it was their failure. It was their breach of failure for not submitting my paperwork to the Federal Motor Carrier Administration. So that was a win in itself. No insurance company ever admits fault in writing, and they sent it to me. So that was the first win. Now the
Okay.
second win, man. Oh, I'm telling you. Okay, so I still have not settled it, and it's been 4 years. But I caught COVID, and on my insurance policy, disease caught on the job was included, and COVID was a bacterial infection or whatever. So I was covered. So I had to sue myself, right? No, let me take that back, y'all. See, take notes.
I
A
remember this.
corporation, yep, a corporation is not the same as an individual. So I had to sue the corporation that I incorporated, that I'm the owner of. But guess what, y'all? The insurance company knew all this before they even gave me the insurance policy. They said, Miss Fox, we're not going to insure you. I say, no, if I'm paying over $3,500 a month for my trucking company to exist, you insure me. I want a clause that say all officers insured. And they did it because I wasn't going to pay them over $3,500 a month and them not insure me. And
Right.
I'm driving it.
You just went out on
All officers included. That was my other win.
us.
So now that
That's
I'm in
two.
workers, it is. This is what I'm trying to tell y'all. I have a win. Um, so now that I'm fighting the claim in workers' comp court here in Illinois, um, man, whew, the attorneys the insurance company hired didn't want to talk to the corporation. Okay, they didn't want to talk to the corporation. Um, so I made a phone call 6 months into the case to the attorney representing the corporation, because hey, if I'm president of the corporation and I'm acting in my official capacity, you have to talk to me about this claim that the corporation paid to insure its employee. I don't give a damn if it's me. I'm not coming to you as an individual. I'm coming to you as the president of this corporation, the head of the thing, right?
Right.
He refused to talk. So I called him a second time and I screenshotted the call log, y'all. The second time he talked to me for 4 minutes, over 4 minutes, okay? And then he still didn't send me what I requested. Then a month later, I sent a certified letter to the law firm and to his attention. And I asked for a hell of a lot of documentation. I told him that they can't make decisions without um, a board resolution appointing a spokesperson for the private corporation, because nobody can make corporate decisions for a corporation except for the board members. And I said, without a resolution, a written resolution and confirmation that we agree to anything, you can't do it. So these fools, they didn't know who they were messing with. But
Hmm.
anyway, they did it. They made decisions without the corporation permission, even after that they received that certified letter. Then once the appointed person that we all voted on to be the speaker for the work comp case sent her official letter to them, they ignored it. And he said that he reached out to the insurance company, but they didn't know who this person was. Although 2 years previous, she was on the policy as a driver, and then we transitioned her over to a dispatcher, and it's reflected. And guess what? I saved the policy that they sent confirming that this person that moved from a truck driver to a dispatcher was insured in a different capacity. Now her name is on the policy. It had to be sent through U.S. mail, so I still had the envelope and the paperwork saying they changed her. So his lie was he didn't know who this person was. Well, it's not my fault you don't know your case information, because if the insurance company hired you, they should have gave you a roster of all of the employees that were insured, because I gave it to them to insure these employers, right?
Right.
Employees, I'm sorry. So they kept on fucking with me, pardon my French. So I turned them in to the ARDC, that is the Supreme Court arm of the investigations into attorney misconduct here in Illinois. These people did the investigation. They sent the attorney out a 14-day letter because they saw it was some validity to what I was telling them. I sent them receipts. I sent them the certified mailings. I sent them the screenshot of the call logs with this dude and everything.
Hmm.
Guess what they did? They made him like tell his side of the story, and then they sent it to me. Everything they sent to everything this attorney, corrupt attorney, sent to the ARDC, the ARDC sent it right back to who? The corporation board. And guess who the head of the corporation board? I am. I'm the president.
It's over with.
Okay. This man threw all them attorneys, the insurance company, the adjuster, he threw them all under the bus. He said the insurance company told him to take the steps to get the stipulation of attorney, but they didn't use an officer of the corporation. The adjuster signed a legally binding court order stating that she was the corporation head, and they submitted that shit in court, y'all, and didn't think I was gonna know.
They stupid.
He admitted, man, he admitted to the Illinois Supreme Court that they schemed to do this. So guess what? That's a class 4 felony right there. Another thing, after COVID, I'm a American with disability, so I'm protected under the ADA, which now makes it a aggravated forgery and identity theft on the ADA Title 5 protected individual, and they interfered with my work comp benefits.
Yeah, they going to jail.
Oh,
Them
exactly.
insurance, they don't be playing when they find out what them folks did. But it's just one of them things to where like everything that you're saying, it takes you to know what's going on,
Right.
to know the law.
Yep.
You know.
So, long story short, y'all, because I have been doing my studying, every time these people have went to court and got a continuance to delay me getting my benefits, it counted as a fresh offense of the class 4 felony to delay and deny benefits to an ADA protected person. Every time they step into court, they're creating a new offense, a new charge. Every time they submit something to the court, every time they speak on record because of the forgery, they commit a new offense every time they step into court.
Yep.
So, with that being said, y'all go beyond just arguing with these attorneys. Call them out on their bullshit and take your case to the ARDC in your state. Because guess what? If y'all do that and y'all have to have material facts to support it, not just a grievance saying y'all don't like the outcome of a case. Y'all gotta give specific facts as to how this attorney had misconduct or whatever. And they will send that 14-day letter out, and then they have to tell their side of the story. And guess what? You get to review it, and
Yep.
then you'll have evidence. So this
Yep.
this is this is my testimony, and I just wanted to share how y'all go beyond just arguing with these fools in court. And y'all also can report judge bias, prejudice, and even if the judge yell at you from the bench, guess what? That's misconduct.
Yep.
He's not allowed to show bias. This is what I'm learning, y'all. I just reported a judge in a case for yelling at me
Mm-hmm.
because that shows bias, because he wants to allow the attorneys to continue the forgery. But guess what? The next step is to report it to you guys as inspector general in the state. The inspector general is a individual task force that is separate from any division in government, and they have to um like investigate fraud on the of state employees because it's going to save them money. So it's in their best interest to do their job so that they find money to put back into their budget because of the fraud and all that from state employees. I don't know if they got like a separate insurance policy or something on state employees to cover liability, but they go after these people. So I'm filing my inspector general report after I get off this call. But I just wanted you guys to have more tools in your arsenal because my um my law studies came about partially because of this group and others, but this group has been a big part of that influence. I'm grateful, but I also want to share what I've learned in my along my journey with y'all because it is propelling me to be able to get the outcome that I desire with this case.
Absolutely. And that is what it absolutely takes is to, study to know and do handle your business. Somebody said Louisiana Inspector General told me in our email they do not assist the public, they assist the state. That's what she was saying. So they going to go find out the situation based upon the state's behalf because they want to save money. If they can find it first, then and the money that they find with the situation, it pays back into the state, then they ain't got to worry about dealing with you type things. So, that will definitely get them to still correct the matter, no matter what, regardless. And
Yeah, maybe. Oh, go ahead. I'm sorry.
now I was just saying,
Um,
like, because a lot of people say, like, ask certain things and about when it comes to you can't see this is you cannot you can inform them of something that has taken place, but that don't mean they're doing it to assist you.
exactly.
They're doing it for checks and balances within their government, and they're going to investigate it themselves. Because if they can find it from keeping further harm, and it's actually something that is true, then they need to stop it before it happens to 100 more other people. That's the point of what they do. So it's not a bad thing. You can definitely inform them of something or a situation because at the end of the day, if they find that person that you informing about, you're not even asking for help. You just letting them know, like, hey, this is what's going on. You might want to investigate. And that's just it. So, but thank you though. Thank you. That was a powerful testimony. So I appreciate you sharing that. I remember even you saying these things to us, and just to hear you coming out on top throughout this as well. And just keep continuing.
Thank you. I appreciate it. Thank you so much.
Anybody else? Anybody else with a testimony before we push forward? All right, y'all working?
all the time.
All right, as long as y'all working now, make sure y'all working. All right, so let's just jump into what we was doing. I think we stopped at what, chapter 4? Was it chapter 4? Y'all don't remember, huh?
Yeah, chapter 4, chapter 4.
Chapter
Mm-hmm.
4.
It was chapter 4.
Okay, y'all do. I'm sorry, excuse me. Y'all remember. All right, well, let's start on it. We are in the Declaratory Judgment ebook. Here is what I'm reading from. That is from In God We Trust Academy. You can either, like I say, get the 2 raffle tickets. You can get this, or you can go on to our website. Either or, that's all you got to do. So now, the State Declaratory Judgment Acts and the Uniform Declaratory Judgment Act. So let's see. The purpose of this chapter is to explain the role of state declaratory judgment laws and how state courts exercise authority to determine legal rights and relations to declaratory relief. All right. So the state court possesses broad authority under declaratory judgment statutes to determine the rights and legal relations of parties involved in actual controversy. Because the state courts exercise general jurisdiction over a wide range of civil disputes, the scope of declaratory relief at the state level is extensive. Courts may declare legal rights involving personal status, contractual relationships, property interests, and other legal relations governed by state law. One area of jurisdiction involves the determination of legal status. Legal status refers to the legal condition or classification of a person or entity under the law. Disputes concerning status may arise in situations involving the validity of legal relationships, the authority of trustees or fiduciaries, the rights of beneficiaries, or the legal recognition of organizational structures. Declaratory relief allows the court to clarify the legal standing of individuals and entities so that their rights and responsibility are clearly defined. State courts also exercise jurisdiction to declare legal relations between parties involved in ongoing disputes. Legal relations refers to the network of rights, duties, and obligations that exist between parties under law. And when parties disagree about the nature of scope of these relations, declaratory relief allows the court to determine the lawful framework governing their interaction. So this is particularly useful in situations where parties must continue interacting under contracts, business agreements, or regulatory frameworks, but cannot proceed because the legal obligations remain uncertain. So contract rights represents one of the most common subjects of declaratory actions in state courts. Contracts form the foundation of countless personal and commercial relationships. So when parties disagree about the meaning of contract terms, the validity of the agreement, or the obligations created by the contract, declaratory relief allows the court to interpret the agreement and declare the rights and duties of the parties. So once the court clarifies the legal meaning of the contract, the parties may proceed with their relationship according to judicial determination. So this is why when I taught the class tender of performance is why I was telling you guys to use declaratory judgment and go and seek a relief there, because it's just to the point to where it's about the obligations or what are the rights in the situation to where somebody has defaulted in their performance and you cannot continue to accurately perform your obligations without mutual performance from the opposing party. So therefore, you want to know your rights or interests in this situation, or are you to be fully discharged of all of your duties? That's what you want to know, all right? Property interests also fall within the scope of declaratory jurisdiction in state courts. Property disputes often involve competing claims to ownerships and possession or uses rights. These disputes may arise between individuals, businesses, neighbors, or governmental entities. Declaratory relief allows the court to determine the legal interests held by each party and establish the lawful boundaries of those interests. This determination resolves uncertainty surrounding property rights, and provides a stable legal foundation for future conduct. For the citizen, the scope of state jurisdiction means declaratory judgment is not confined to a narrow category of cases. State court possesses broad authority to clarify legal rights and relations whenever an actual controversy exists. So this makes declaratory relief a versatile legal remedy capable of resolving many forms of legal uncertainty encountered into everyday civil disputes. So then there is contract interpretation. So if you don't truly understand what's in the contract, and you can go get a declaratory relief on that. And a lot of people probably need to. If you don't understand, and if you do take that into consideration, then yeah, go and get that. Make it known. And remember, the main word in declaratory is clarity. You want clarity of the situation. So you shouldn't have to go and perform anything, right? So performance obligations are frequently become the subject of declaratory actions. Contracts often impose specific duties on the parties, including obligations to deliver goods, provide service, make payments, or comply with certain conditions. When the parties disagree about whether these obligations have been satisfied, meaning you made a tender of performance, or whether a certain condition has been triggered, declaratory relief allows the court to interpret the contract. So if you do a tender of performance, it triggers them to give full accounting, full disclosure, so that you can do an accurate performance. And if they do not, now you want to know, what are your rights and interests in this particular situation? Does this discharge you from your obligations because they won't perform theirs and they defaulted? This is a very powerful method, right? So it also addresses the risk of brief. A party may believe that the other party intends to act in manner inconsistent with the terms of contract. So in such situations, waiting for an actual breach to occur may cause unnecessary financial damage or disruption to the party's relationship, right? So what is the risk if you continue in this manner? You can decide that as well. But you have to know that it can't be something on the future that has not taken place, right? It has to have already happening, or it's in the risk of happening. If continuance, right? So you want a real declaratory relief. Now, when it comes to property rights, is there anybody competing for the particular property? And before you go through an expensive situation, if it deals with land through probate and all of that type of stuff, then why not do a declaratory relief and get the situation handled in that way, so you can actually know the actual rights to the property. When it also comes to quiet titles, when it's time to do that. And this could happen, because property rights happens if, let's say there's a foreclosure and you do a tender of performance and they fail to perform, and you get to do this. They have to perform because they're trying to enforce something. So you just want to know and make sure they have the authority to do what they're trying to enforce. And now they have to open their books, because the minute they move into enforcement, you got to show everything, no matter what. Ain't no running from it now, for sure. Right? So now you want that to particularly happen, right? And if they don't do certain things the way they're supposed to, and it does just fully discharge you of all obligations, and now you got the right to acquire. It's a quiet title dispute, which represents one of the most common forms of declaratory property actions. In a quiet title action, a party seeks a judicial determination confirming their ownership interest in property and eliminating competing claims that cloud the title. So now, because they don't perform, you want to do a quiet title on it because they didn't perform. So it's discharging you of your duties. And now you got full rights and ownership. They no longer can have a lien on it. You can do this through a quiet title. Such disputes may arise when multiple parties assert ownership rights, when historical records are unclear, or when prior transactions have created uncertainty regarding the chain of title. Declaratory judgment resolves these issues, establishes clear ownership, and removes obstacles that might otherwise prevent the property from being sold, transferred, or financed, right? So easement rights are frequently give rise to declaratory litigation. Easement grant one party the right to use portion of another party's property for a specific purpose. So if that happens, then, they agree to be able to use the property to grow, then whatever percentages, stuff like that they may have. If they can't come to a form of agreement, then a declaratory release has to be sought out in that as well. And even when it comes to boundaries, like, hey, is your fence on my land type thing. So instead of going through so much of the other stuff, you can go through a declaratory judgment and we can determine from right then, right? Government actions is another one. Declaratory relief also plays a significant role in disputes involving government actions and administrative authority. Government agencies often exercise regulatory power through statutes, regulations, and administrative orders. When individuals or organizations believe that these actions exceed the authority granted by law or based on an incorrect interpretation of statutes, declaratory judgment provide a mechanism for judicial review, right? But you're not going to them to be like, it has to literally be a dispute, okay? You can't go to be given clarified of what is your, be taught the law, so to say. They're not going to do that, right? But it has to be a dispute and actions that takes place with a formal government agency. So agency regulations are one area where declaratory relief may be sought. Administrative agencies frequently issue regulations designed to implement legislative policies. However, disputes may arise concerning whether a regulation falls within authority granted to the agency by statute. A declaratory action may ask the court to determine whether the regulation is consistent with the governing law and whether the agency acted within the scope of its authority. So now that's basically a challenging of the freaking jurisdiction. That's basically what that is. It's exactly, ain't no basically what it is, exactly what it is, right? So administrative orders also may be challenged through declaratory judgment. Agencies sometimes issue orders requiring individual or business to take certain actions or comply with regulatory requirements. But again, do they have the authority? So it's always question the authority. From where does your power come from? Can you show it? You know, we have to be able to see. Statutory interpretation disputes frequently arise in cases involving government authority when agency applies statutes in a manner that affects the rights or obligations of citizens. Disagreements may occur regarding the meaning of those statutes. And this can happen when you got situations going on if you're trying to receive any type of funds or benefits from these particular agencies and they choose to hold over your head and what they think and consider income. And if you know how to deal with that situation, you can come get a declaratory relief on it and not have to go through their agency to let them decide whether it is or not, especially when you know you're right. So, for the citizen, declaratory judgment provides an important safeguard when dealing with government authority. It offers a lawful method for requesting judicial clarification when administrative action raises questions about the legality of regulations, orders, or statutory interpretation. By allowing courts to examine these issues, declaratory relief ensures that government action remains subject to legal scrutiny and that the rights of the individuals are protected through the rule of law. That's where you want to be, right? So now we're on procedural. Now, procedure matters. Procedure matters because if you came to the Lawman Volume 2, we were on procedure is power. And if you fail in procedure, then you're going to fail to get your remedy. You will lose power. So understand that. The purpose of this chapter is to explain how declaratory judgment action must be properly presented to a court through a well-structured pleading. So declaratory relief is not granted simply because a party believes a legal question exists. The court can only exercise its authority when the dispute is presented through a complaint that clearly identifies the controversy. So remember, controversy has to be there. Then you have to establish the court's jurisdiction and demonstrate that a judicial declaration is necessary to resolve the legal uncertainty between the parties, meaning that you have to prove that this is the only method that is precise to solve this, right? Before it goes into further costly litigations. And if the declaratory relief itself is not going to help you, then they will definitely say, hey, us deciding over this decision or matter is not going to fix the problem. So you have to make sure that, well, this is the place for it to be and decided to actually fix the problem. So a declaratory judgment complaint must contain specific elements. I want y'all to be writing these elements down that demonstrate the court's authority to resolve the dispute, establish the legal basis for the requested declaration. The elements ensure that the court can evaluate whether the action satisfies the jurisdictional and procedural requirements governing the declaratory relief. So the first requirement is jurisdictional basis. All right. It must explain why the court has legal authority to hear the case, and this involves identifying the statutory or constitutional grounds that give the court subject matter jurisdiction over the dispute. All right. In federal court, jurisdiction may arise from presence of federal question or from diversity of citizenship between the parties. In state court, the jurisdiction typically arises because the dispute involves matters governed by state law. Clearly stating the jurisdictional basis assures the court that it has its power to adjudicate the controversy presented. So now, if you in a contract and it says that contract is governed by the state laws of Alabama or Mississippi or Florida, wherever it may say, then guess what? That state and that particular court, if it's in the right court based upon whatever, it has that power. Declaratory judgment can be sought in that state because that state laws governs it. So yes. All right. The second requirement is a clear statement of the controversy. Clear statement of the controversy. The complaint must describe the dispute between the parties in a manner that demonstrates the existence of an actual controversy requiring judicial determination. This portion of the pleading should explain the circumstances that led to the disagreement, the conflicting positions taken by the parties, and the specific legal issue that remains unresolved. The court must be able to see that the dispute is real, immediate, and grounded in concrete facts rather than speculation or hypothetical concerns. The third requirement involves identifying the legal interests or the parties. All right. Identify the legal interests of the parties. A declaratory judgment action centers on determining legal rights and obligations. Therefore, the complaint must explain the legal interests held by each party in the controversy. And this may involve describing contractual relationship, property rights, statutory duties, or regulatory obligations that form the basis of the dispute. So by identifying these legal interests, the complaint shows how the parties are connected through a legal relationship that requires clarification by the courts. So the fourth requirement is a request for a declaration of rights. Request for a declaration of rights. The complaint must clearly state that the plaintiff seeks a judicial declaration determining the legal rights and obligation involved in the dispute. This request informed the court that the purpose of the action is to obtain definitive legal determination resolving the uncertainty affecting the parties. The requested declaration should be framed in a way that directly addresses the legal question at the center of the controversy. So for the citizen, these complaint requirements ensure that the declaratory action presents a complete and organized explanation of the dispute. By clearly identifying jurisdiction, controversy, legal interest, and the requested declaration, the complaint provides the court with information necessary to evaluate the case and to determine whether declaratory relief is appropriate, right? So, now you know. Essential elements. The essential. So when it comes to first essential element is existence of an actual controversy. The second essential element involves identifying legal rights at issue. The third essential element is the immediate need for judicial determination. And these essential elements demonstrate the controversy is suitable for declaratory judgment. Now, you also got to make sure that you pray for a relief. And this portion is for the complaint that formally states what the plaintiff is asking the court to do. So in a declaratory judgment action, the prayer for relief focuses on requesting a judicial declaration that clarifies the legal rights and obligations of the parties involved in the dispute. This is very important because if you ask the court to do something it does not have the power to do, it cannot grant it to you. It does not have the authority to do so. So you got to make sure that is fully stated. So one common request in declaratory action is a declaration of rights. And this type of request asks the courts to determine the legal rights possessed by the parties under the governing law. For example, a party may request that the court declare that a contract is valid and enforceable, that a statute applies to a particular situation, and that property interest exists in favor of the plaintiff. So the declaration establishes the legal rights of the parties and resolves the uncertainty surrounding those rights all day long. Okay? So a sample structure is making sure that you address the jurisdiction. The next section needs to identify the parties. And then you need to have a fact section that follows. And after the facts are presented, the complaint typically includes a section describing the controversy, right? And after that, the legal basis section that explains the legal principles governing the actual dispute. And then you want to have the final section that contains the request for declaration. And if you know me, truth, proof, law, relief. Always make sure you have those things. So, for the citizen, this structural approach to pleading ensures that the declaratory action presents a complete and coherent explanation of the dispute. And by organizing the complaint into a clear section addressing jurisdiction, parties, facts, controversy, legal basis, and the requested declaration, the pleading provides the court with a comprehensive framework for evaluating the case and determining the legal rights and relationships of the parties involved. All right, D then. So let's ask y'all questions. Give me the elements.
Jurisdictional basis, here statement of controversy, identify the legal interest of the party, and request for declaration of rights.
So when we say jurisdiction, we are making sure the court has what type of jurisdiction?
Personal.
Okay, because how does the court have personal jurisdiction?
Well, we're proving that they don't, right?
Well, you're the one taking them to a declaratory judgment, so you need to prove that they do.
Oh, got you. I see.
So if you're saying the court, how does the court prove? How do you prove the court has personal jurisdiction over the matter? Number one, you have the right to be properly what?
Properly served.
Okay.
Or
So you have to be served first. Okay. Personal jurisdiction happens by proper service, and that it is also the right court according to the governing laws of this particular situation. So let's say it's governed by in the state of Tennessee. All right. So therefore, how do we show it has subject matter jurisdiction?
statutes, state statutes.
The state statutes of what? We say in Tennessee, right? Okay, gotcha. All right. Now, how do we determine territorial jurisdiction? Y'all need a lifeline?
Yes, please.
It is because the dispute and situation is taking place under the laws of that particular state and jurisdiction. So if it says that this, like I said earlier, that if it's based upon a contract, then it's governed by the rights of the contract. If the state laws of that governs that contract, so that shows territory jurisdiction. If it's governing property rights, then it's going to be based upon what the jurisdiction of what that property is in. So if it's in a dispute within Tennessee, then the state of Tennessee is going to have that jurisdiction, right? And if the situation, et cetera, or whatever has taken place and that has created a implied contract and it happens within the territory of that particular state, then it also creates territorial jurisdiction. Got it?
Got it.
Got it.
All right, so let's get on the offense. Y'all know me, I like to be on the offense. So the purpose of this chapter, we on chapter 6, is to explain how declaratory judgment can be used as an offensive litigation strategy to control the direction and timing of legal disputes. Declaratory relief is not only a defensive tool used to respond to claims brought by another party, it can also be used proactively by a party who seeks to resolve a legal controversy before the opposing party initials enforcement, such as foreclosures and things, file suits, or takes action that may increase liability or escalate the actual conflict, right? So preemptive litigation refers to the practice of initiating declaratory judgment actions in order to resolve a dispute before the opposing party files suit or initiate enforcement actions. Ain't that me? I always tell y'all, jump out there first. Jump out there first. The strategy is often used when one party asserts a legal position that threatens the rights or obligations of another party but has not yet taken formal legal actions, meaning they finna foreclose on you. You know they is. Y'all know. Yeah, I'll be like, when the last time you paid them? Oh, I haven't paid them in 15 months. Okay. Yeah, I think it's time for a declaratory judgment. You know you ain't paying somebody in 15 months. They definitely coming. Jump out there before they get to you, right? Make them come answer to you because you know they're coming. Declaratory judgment allows the affected party to bring the dispute before the court and request a binding determination of the legal issues involved. So, one common use of preemptive declaratory relief involves determining contractual obligations. Contracts frequently create ongoing relationships between parties who must perform duties under agreed terms. When one party asserts the contract requires certain actions or payments while the other party disputes the interpretation, the disagreement can create significant uncertainty. The party may hesitate to perform or refrain from performance due to fear of breaching the agreement. By filing a declaratory judgment action, a party may ask the court to interpret the contract and to determine the obligations of each party. The court's declaration clarifies the legal meaning of the agreement and allows the parties to proceed according to a definitive interpretation. So, preemptive declaratory relief is also used to challenge potential government enforcement as well. So, its regulatory agency may assert that certain conduct violates statutes, regulations, whatever the case may be. So, this allows the court to determine whether the agency interpretation of the law is valid and whether the threatened enforcement action is lawful. All right. So, you want to clarify statutory rights. It's another important one as well. So, preemptive declaratory litigation provides a lawful way to resolve disputes before they escalate into more complicated or damaging conflicts. Instead of waiting until enforcement actions or breach claims occur, the affected party may seek a judicial determination that clarifies the legal rights involved, which is what I would do. Right? You also got insurance. Insurance disputes frequently involve declaratory judgment action because the insurance policies often create complex relationships between insurers and insured parties. And these policies define obligations regarding coverages, defense of claims, and payment of losses. When disagreements arise about the interpretation of policy provisions of the scope of coverage, a declaratory relief provides a practical mechanism for resolving those disputes. And I say that you need to take those for real to do that because a lot of y'all will allow the insurance people to use a lawyer to send you a letter that is going to fully do it in the favor of the insurance company that pays them to. You ain't paying them, so you damn sure know they ain't sending nothing in your favor, right? Even if they try to lowball you with a payment, because they'll definitely do that. A whole situation worth millions. We'll give you $5,000. What? You didn't call me super harm. You talking about a couple $1,000? Yeah, you tripping. We ain't even gonna go there. And they will do it to you. And you will think that it's right and that you're supposed to accept it because a lawyer offered you a payday. And right then and there, you don't even understand that this lawyer knows he's lowballing you. He knows you're right, which is why they're trying to pay you. And they know that you don't have the money or et cetera to seek any other form of legal advice or representation. They know that. And it's going to be hard to get one against insurance companies because most of these lawyers like to be hired by insurance companies. Y'all know that, right? Okay. So it's important. Intellectual property disputes. Declaratory judgment plays a significant role in intellectual property disputes because these disputes often involve uncertainty regarding legal rights before formal enforcement actions occurs. So intellectual property law governs the rights associated with inventions, creative works, trademarks, and other forms of protected intellectual assets. When parties disagree about the scope or validity of these rights, declaratory relief provides a mechanism. So if you know that you trademark something or you use something first or et cetera, and then now you need to be able to go and, exercise that declaratory right that you have and get a clarity on the situation. So trademark disputes are also commonly involve declaratory relief, and the trademark law protects words, symbols, designs that identify the source of goods or services. And when one party claims that another party use of a mark creates confusion or infringes upon an existing trademark, the accustomed party may seek declaratory judgment to determine whether their use of the mark is lawful. Now, most people, if they do a declaratory judgment, they being nice because most people just gonna sue the shit out you. They not even gonna waste their time with trying to see if you, because they know they rights. They gonna give you a warning. Hey, cease and desist. You better stop. And any money that you made off of using such and such, then you need to give us something out of that in equity, and we'll keep it moving. But if y'all can't come to an agreement about that, then now that's where they probably going to take you to court because they've got proof that you used their trademark name, et cetera, whatever the case may be. And you're going to end up in one of those situations. So also, even in commercial contracts, guys, any commercial contract that you are in, like if you know you in a situation, I keep saying, it's always best to jump out there and handle the situations before they do. Unless you just know they come in and you just keep collecting evidence based on what they do. And then you like, all right, the day they come, I got all this evidence. I'm waiting on them. Right? And then that means there's no court costs for you to pay for all of that either as well. So, I mean, it's totally up to you. But at the end of the day, I like to be on the offensive sides. And, you know, I ain't trying to let nobody jump out there, especially if I already see you coming, because you coming sideways. I've already showed you the law. I showed you where you were wrong. Here's the evidence and some of, you know, just showing you like you wrong. And if you don't try to make amends, you still keep trying to bully and push because you think that we out here as the people we're dumb and you think everybody needs to go get a lawyer just for a simple understanding of what is right and wrong in a contract or a situation. No, we do not. So now I'm showing you the law. I'm showing you where you messed up. I already see you coming. And then if you don't do what is right, then I might as well go in and take you before you try. Because a lot of times you run into situations where the judges and stuff like that, they will jump on the ban of whoever files the case, whoever paid type thing, especially if you pretty much writing your procedure. I've seen it done. A judge comes straight in and say, all right, we're going to go ahead and decide with the plaintiff, but we're going to let the plaintiff know that, hey, if the defendant appeals, they're going to win. But we're going to decide with you. I done seen that happen so many times. But this goes back to this is why it's so good to know the law. Man, I remember that song we used to say, it's good to know. Everybody ought to know Jesus, which is justice. Still to this day. And the only way you're going to get that is just a constant study. And this is the reason why we have to handle things civilly. Because if you don't handle things civilly, you think about every situation that goes to the extent of something else. Like I be watching these people. It's just one dude, he be towing people or putting a boot on people's cars and stuff like that. And he get into it. He get into it with about to fight him and stuff. And it's like, for what? Like if you don't agree with somebody taking your car and you tell them to drop your car and that you do not agree, you shouldn't have to swing on them. You shouldn't have to hop in a car to pull back out. The minute you said no, that means there is no peace. See, people think about that, you know, it has to be a peaceful situation to where they can tow the car. And that means that, oh, you didn't try to, you know, fight back. No, a simple no is all that's needed. That means the situation is not at peace if there's a dispute. Am I not correct?
Correct.
Because, and a lot of people look at it like, oh, there has to be a real full live altercation that is going to disturb the peace. No, it's just the pieces between the parties that's involved. And if I tell you that, no, this is my car, I'm already in a dispute with these people and it's mine, they owe me, this is my property. It's in a dispute. You got to get out the way. If you do anything other than that, you're going to be held responsible too for taking property that had nothing to do with you. And you got to go come show authority. Because if you working for them, they ain't never showed authority. So are you here to show authority? The authority that they have, you got all the accounting measurements and everything. So you here to pick up on their behalf today. You must have what they said they were supposed to, what I asked for. Do y'all understand what I'm saying?
Yep.
It's just really that simple. So I mean, that's what it is. They have to, and you have to know that it's not peaceful, none whatsoever. So if it's not peaceful, then you have to stop right then and there and just, hey, they still in my car. It's theft. From that point forward, it's always theft. See, they not gonna the law is not gonna get involved. At least they're not supposed to. Some of them do anyway. But now that turns it into another situation, but they outside of their jurisdiction. But the law itself says that. You see what I'm saying? The law, it's if you don't pay, it's theft. What do you mean if you don't pay? If they repo, it's theft. Yes, if they repo, it's going to be theft if you say they can't take your car. Because now it's not a peaceful situation. You're telling them, no, you do not agree. And a lot of people think that peace means that breaking a peaceful situation means that there has to be a full blown out like fighting, arguing like a real fight almost, an altercation that is going to disturb the peace. It's already disturbed when I told you no, when we're already in a dispute. So all of that has to go out right then and there. And yes, if they do take it, then it is considered to be theft. And then what I was saying by now they can get involved if you call and say this is theft. See, it's not about why is this considered theft? Because I do not agree with them taking my car, right? And the law says that they're not supposed to take this if it's not a peaceful situation, basically, right? Everybody understand?
Yep.
So the situation is if everybody having a hard time to understand about what the statutory is saying, and then in this particular situation, and there's a dispute between these parties, now we can go and get away, guys. All day long. And who gonna win? We are. You see what I'm saying? Like peace not peace. The opposite of peace, it is a form of violence, but I'm just saying, like, it don't have to be violence. It could just be a full disagreement. And if there's a disagreement, there's no peace in that situation. There's no settlement. Peace is to be settled, right? Y'all gotta know that. So don't just be looking sad because these folks just up and jumped and took the car. Okay, well, show me, because I'm still in a dispute with these folks. Yes, people have been unalive in that situation. It happened here in Decatur, Alabama. And the officer is locked up right now. But they've been harassing the wife because they suing them. And this situation was crazy, man. Shout out to, may his soul rest in peace, Steve Perkins. For sure. They were sitting outside his house in the dark on the side of his home while the tow company was getting ready to tow it. He came out with his gun. Now, mind you, dude caught up on his pavements, everything. They ain't even supposed to be towing the car, nothing. But then the officers jump out like an ambush and gun him down because he had a gun. Tell the dude to get off his property. All he heard is somebody trying to take his car. And they ain't got no right to take it. And this is why I say peace is saying, no, you cannot take my car. That means you have to go, not the officer deciding with the damn tow company and end up killing the man. And he got the right to protect his home. They even took it to the Supreme Court. The Supreme Court, the judge said, so he said, you mean to tell me that he wasn't supposed to come outside and protect his property and home to see who's outside, and and to see who outside, and so this is the attorney trying to explain, like, yeah, it wasn't the right equal amount of force or something. Sometimes he was trying to explain it, which is why it was a crime or the intent or whatever he was saying. But anyway, it didn't make no sense, and the Supreme Court judge let him know that. He said, you come to my house. That's what you do, and I'm gonna come out with something just is bigger, pretty much. He was basically telling him, come on to my house and find out about the Second Amendment. Come find out about it. You know what I'm saying? So he was just letting them know, like, your officers, they messed up. They was never supposed to come out and do anything. You mean to tell me a person can't walk outside to protect his home, to make sure that his property is safe, etc.? He was like, yeah, come to my house and find out. This is Supreme Judge telling you that. You understand what I'm saying? And then here you have an attorney who's paid, and his seat, and everybody. The thing is, like, the attorney job is not to, his job is to argue something. Even if he have a chance of winning or not, he has to try to make that argument to interpret it, to persuade, to get it in his type of way. See, that's what the things attorneys has to do. They have to be good at manipulating and things of that nature. A good attorney just know to use the law itself, and that's okay. But see, the other ones, they just get paid. They're not gonna tell you like, "Hey, man, we ain't gonna win this." They're gonna take your money. Oh man, we got a good chance, and they're gonna go argue because that's all they told you they was gonna do. And they're gonna tell you which side they coming from and how they gonna argue, even though they had no chance of winning. But they went and argued it for a long time, all the way to the Supreme Court. This is their chance to make this argument. They will do this to you. So this is why it's important for you to truly understand the law. Because if you don't, you end up in situations that you really would have been fully protected by God. But you didn't have knowledge of God and the knowledge that God has given you to protect yourself. The story is always about law, order, and justice, family, because we have to have it. Just think about right now. If all the matter of fact, when the traffic lights shut down, what everybody do? They panic. Boy, they get to panic and skirt. People don't even know when to go, stop. They looking crazy. They need somebody to come and direct the traffic in law and order. You see what I'm saying? It's the same thing. So if you take away the law and order right now, and you take away the 45 speed limit, I got it right here in front of my crib right now. They treat this more like a drag strip. Straight up. I'm talking about full, and the police is right next to us. The sheriff department right next to us. And they treat this more like a drag strip every day. Wide open. I'm talking about, hey, that light hit green. If it's a muscle car or anything like that, they finna hit it every day. So imagine you take the law away and you allow these people to hit 65, 75 up and down this little road. What you think gonna happen? If a state trooper is not there to keep you, or officer is not out there to keep you in line, you're going to kill somebody. Remember, somebody drinking, somebody under the influence on the road. Y'all want to let this person drive at 80 miles an hour with him not even trying to drive at least the speed limit, even if he can't hold it in the road too good. You see what I'm saying? A lot of accidents, hit and runs, all this going to happen. Your car gonna get stolen. Cars already being stolen. And they wearing masks and fear the law. You take the law, they just gonna come up to you. Hey, I want your shit today. Come up out of it. No consequences. What you would get, and that is the whole point of what's that show? What's that show, guys, where they allow all the lawlessness to take place and they call it cleansing their soul? What's the name of that damn movie?
The Purge.
The Purge. That's exactly what you would see. The Purge. That's the whole point of it. Because everybody feared the law. But there's just one day where there's no law. You don't have to be in fear of the law. You don't have to be worried about facing justice or anything like that. All the people get to bring out that lawlessness out of themselves in every shape, fact, and form. They didn't care about if it was doing some harm to children, women, this, that. It was lawlessness. And the whole point of that picture is to show y'all how important the law is. Because if they get like this, then you're going to see what? They already showing you that the politicians and stuff was fixing the damn game of lawlessness. They was lawlessness. They was in lawlessness anyway. from the very get-go. This goes back to telling you why you need to know the law. And then the whole entire thing, they end up fighting who? The government, right? Because in these higher places, evil is already existence. It's corrupt. So it's important. They are speed traps. But see, you got to understand what speed traps are and how you can get out of those speed traps. Because you can easily be one. This one over here, it goes from it's a 70 and then it hit 55. I'm talking about like I'm talking about quick. It ain't even 15 yards apart. It's a 70, 55. I'm like, dang, y'all really trying to hang one quick. You gotta slam on your brakes to make this. Like you gonna hurt somebody. What are you talking about from 70 to 55? And I'm talking about literally, y'all. It's like it's probably about 10 yards at best. I'm gonna record it. I'm gonna show it to y'all one day. I'm gonna show it. It's 70, 55. I'm like, whoa. But you can beat that though. That's easy to beat in court. Simple. You know what I'm saying? Like they gotta be realistic about the situation. that's not taking care of public safety. You want somebody to slam on their brakes that fast and to slow down. What is the reality of a car being able to slow down that fast and as soon as you run? Yeah, okay. Soon as you run past the sign and they like, okay, yeah. We clocked you at 60, 65, 64. Hey, man, I ain't even had time to hit the brakes good. You know what I'm saying? Then if you in certain cities, you drive the speed limit you want to, you getting ran off the road. Quick. They don't even, and then you will see the police driving by you fast. He's scooting too. You know what I'm saying? It's like, how you gonna pull somebody over or do anything and you speed? But all this goes to us knowing the law. Remember, y'all sovereigns out there, govern. Use the law to govern them. The statutory laws commands and prohibits the government from what? Government overreach into the private citizen matters. That's what it do. And it governs the public for public safety reasons. But public safety is never supposed to be an overreach into personal liberty unless it has to take personal liberty from everybody, not just specifically you. Right? Compelling interests of a government. The compelling interests of a government, such as everybody got mad. No more prayers in school. I never forget when they said no praying in school. My mama was pissed. They taking God away. Hey, my folks was mad. What about y'all? Was y'all folks mad? I was mad. They taking God out the system. Yes. And they not but the reason why they feel like that is because they don't understand the law. Christians, and that's what people think. Y'all think y'all the only people that's religious or something. That pray or got some type of way of praying. You're not. So you got to think about it. If they allow the Christian to pray, whom likes to hoop and shout, and not all, but I'm just saying, you know how we get down. That's how y'all gonna pray. Then you got the Muslims to say, "Oh, I gotta pray," right in the middle of the teacher saying, right in the class, right in the middle of reading. Let's say it's this, they turn to read, present, whatever. They gotta stop and pray. They got to. So you can't stop the classroom and pray, but they can't also stop you from leaving the classroom to go pray. You just can't disrupt in the classroom. You see, you understand what I'm saying? So that means that if you had to go and establish and write a letter for your child to do such and such at a certain point of time, then there you go. That's just what it is. Do you have to change your status to work some of these ebooks in your store? Listen, you already in the correct status. You already in the majority status. The only time you become not in the majority status is when you're incompetent of your situation that you are in. Now you become a minority because you have to either hire a lawyer or get somebody that does know. Maybe you got to get power of attorney away or something of that nature. That's it. Everybody in their right place right now. Right? Now, you can also use declaratory judgment as a shield. You can prevent wrongful enforcement, such as foreclosures. Right? You can stop governments from using their regulatory threats. They threaten you guys that if you don't get hit in the arm with something that's metal and that shoots out foreign entities into your body, and that if you don't do that, that you can't work there. You can't graduate. Yeah. You need to challenge that. Because your right to exercise your religion says something different that is protected by the First Amendment. So do they policies or regulatory actions violate? So now you got to ask them, from what authority, from where does your authority come from to take away my right to exercise my religion? Yeah, show me. And they can't show you. They can't show you at all. So when it comes to property and foreclosure disputes, it's about financial and personal interests. So the chain of title disputes also frequently arise in the property and foreclosure litigation, and the chain of title refers to the historical sequence of ownership and transfer associated with a property. And remember, the mortgage has to follow the note. They cannot do an assignment of the mortgage and not transfer the note, or vice versa. If that happens at any given time, because let's say that it's transferred with the mortgage and note one time, and then the next time they do it with the transfer of the note, and they forgot to assign the mortgage. But then let's say that this person gets it and they do a transfer of the note, and then they even do an assignment of the mortgage. And then this continues on, right? And then you say, hey, show me proof. And let's say that you get to see the whole entire chain and you say, oh, this whole entire time they've been thinking they've been assigning the mortgage, but they forgot on the second transfer and assignment of the mortgage. They didn't do it here, even though these other ones think that they're assigning it, but they never received the assignment from 3 or 4 transfers ago. So if you see that, that means chain of title is what? Broken. Do they have the authority to foreclose, family?
Nope.
Not anymore.
Exactly. So they could think that they have it because who previously sent it to them did do an assignment, but 2 transfers and assignments ago, something didn't take place. So you really don't have the authority. Seriously. Right? So how do you enforce the situation after declaratory judgment has taken place? Right? This is very important. Okay? Purpose of this chapter is to explain how declaratory judgment may lead to additional judicial remedies once the court has determined the legal rights and relations of the parties. So once a declaratory judgment has been entered, a party may seek supplemental relief when necessary to enforce the rights established by the court's declaration. Supplemental relief refers to additional remedies requested after the court has determined legal relations of the parties. And these requests are typically presented through motions filed with the court asking for specific enforcement measures. So, one form of supplemental relief involves the issuance of enforcement orders when a court declares the rights and obligations of the parties. Those declarations define the legal frameworks governing the dispute. If a party refuses to act in accordance with the declaration, the opposing party may request that the court issue an order requiring compliance. And if they don't, it becomes contempt. Man. Such enforcement orders ensure that the declaratory judgment produces meaningful results rather than remaining a statement of rights without practical effect. So injunctive relief is another common form of supplemental relief. An injunction is a court order directing a party to either perform a specific act or refrain from a certain conduct. And after a declaratory judgment clarifies the legal rights of the parties, an injunction may be necessary to prevent actions that would violate those rights. So you can go immediately and take that declaratory relief and go and get take that judgment and go and get a injunction if it requires one, if they do not cease from their conduct and things of that nature. For example, if the court declares a party lacks authority to enforce a contract provision, the court may issue an injunction preventing the party from attempting to enforce provision in the future. Supplemental relief motions allow the court to transform the declaratory judgment into a practical remedy that governs the conduct of the parties. The motion procedure ensures that the court has an opportunity to evaluate whether further enforcement measures are appropriate based on circumstances following the declaration. By reviewing the motion and support and the surrounding facts, the court determines whether additional relief is necessary to ensure compliance with its judgment. So, for the citizens, supplemental relief demonstrates that declaratory judgment process does not end with the declaration of rights. If the declaration alone does not resolve the dispute, or if one party refuses to respect the court's ruling, and the legal system provides mechanisms for obtaining further relief that ensures the judgment is properly implemented, right? So, just make sure that you understand. Evidence and proof of everything is so important. Plays the biggest role in what you're doing. Make sure you got evidence, and that's why I tell you first, before you go into a full declaratory judgment, you want to be able to do first what you call a private administration. And private administration is gathering of evidence. Is really what you're doing. You're trying to settle the matter privately, right? And if it cannot be settled privately, then now you have enough information to go into as evidence to use on your behalf in a declaratory judgment that you want to do, or if you need to sue some type of tort, breach contract, whatever it is that you may want to do, you have your evidence and proof, right? Want to make sure that you have those things. Make sure. Okay. All right, we're going to stop right here at this particular time. We're going to see if you guys got some questions at this point and see what's on y'all mind as well. So, any questions? Is this explaining, because we've been doing stuff talking about going to do a declaratory judgment, but again, I forgot who asked us to do this. It was somebody, but we doing it. Does this help clarify to you how and what it's for, and actually when to use it and how to use it? Why, especially if you took the tender of performance class, does this help show you more of why you need to use it? Because yeah, you have a template there, but is it pushing you further to understand it more? Go ahead, Heather.
Oh, it's definitely helping me understand more. And I actually have a question about my case, but it doesn't have to do with declaratory judgment. Is that okay?
Yeah, we're gonna come right back. I'll make sure I get it before we get out of here. Anybody else?
Okay.
Anybody else?
From what I understand, it has to be knocked out so that way you could be able to exhaust all remedies, right? That's something that if you're in that position, you should be using it just in case whether or not they agree to whatever it is, right?
That's right. You have to, because again, it's so important to understand timing. Timing is the actual matter of the situation. Timing is everything. So, is it a situation where you have to get up and go into the declaratory judgment because of, you've asked for documents to be presented to you, and then you got to ask yourself, was those documentations properly presented? You know what I'm saying? And if it wasn't, then they're going to get to go into foreclosure on you after you just tried to handle it privately. You got to understand, guys, they going to do their procedure no matter what, right? If they didn't answer you, just know they still over here going through their procedure. They just trying to count down the days of when they have the time to take you into court, all this type of stuff, right? Even when they not answering you. So you got to be on your procedure. You got to be like, all right, I got enough evidence. You didn't answer, you defaulted, you didn't say enough, you didn't, whatever the case may be. So now declaratory judge, I got to get in there now. Because if they get to me in this particular court, if they try to bring me in this particular court over foreclosure, then I might run into appeals and all this type of stuff because they're not going to fully, you know, preserve the law and the record. Well, you're going to preserve the record, but it's going to take you through so much more when you can go ahead and get them in. And now they can't go into their court because you filed first. So the situation is already in dispute or being handled. And it's in your favor based upon what you want to speak on the matter about in the first place. You see what I'm saying? So you automatically start off with raising your issues and defenses against the situation at the very beginning. And they have to come to you to answer for that. Instead of you having to go to them. In this main particular court, usually like small claim courts as well too, you got to be watch those, but they get you in these courts and they have you in to this particular situation. And you might have to go into preserving the record, asking for certain motions. Let's say the judge don't think that that needs to be done, even though it does in your favor. Now you got to go into preserving it, getting ready, objections, getting ready to go into an appeal for it. It's so much. Then when you do this, they got to come answer to you. So yes, jump out there before. That's why I said if you can beat them now, them putting a case in don't matter yet. You can also let it be known in that particular case that they go file that this case was filed first. This has already been taken care of. We need you to dismiss this case. You understand what I'm saying? Got it?
Yeah, definitely. That boxed it all in right there for me. Thanks, man.
Absolutely. You know, we want to believe that every judge is going to do right, but that's not always right. But if you have them dealing with your situation based upon how you brought it, and they consider that the case is ripe, meaning that it's enough for it has jurisdiction, et cetera, all of that, it is able to stand, then they ready to hear what it is that the opposing party has to say based upon what you provided. And they got to come in to try to defend that. You see what I'm saying? Pay as you protest. Yeah, of course. You can do the same thing. Absolutely. Ain't nothing wrong with paying as you protest because you're going to get all that money back anyway. So you definitely can do that. For sure. Absolutely. Anybody else? If not, Heather, what's up?
Okay, thank you. So I had a judgment that I wasn't properly served last year with the Maryland Circuit Court for some. They claimed I didn't pay taxes, and they've been garnishing things. So I went and filed a motion to vacate judgment, and they're saying now that I have to contact the comptroller of Maryland to determine the validity of my motion and have the judgment vacated. So my question is this, are they avoiding like taking my motion or accepting it or?
No, if you put the motion in and it has not been heard, you did a motion to vacate?
Yeah.
Okay, so send a judicial notice about their duty to up under the procedure that when a motion to vacate is done, they have to have a hearing on that particular motion, and them not fulfilling their duties is a violation, and it's a violation of due process as well in this or procedure. So point to the particular rules of procedure that speaks on motion to vacate, and you point to where they have to have a hearing on the motion as well. And if they choose not, then that's when you go up to a higher court for a writ of
Okay.
mandamus a writ of mandamus to mandate them to have a particular hearing or grant, whether they grant or deny the motion. They have to do it. They can't just sit there.
Okay. Thank you.
Can I
Uh,
can I add something, Eric?
sure.
Um, Another powerful thing that I've learned in my fight with my case is the power of subpoena. If you are a litigant pro se, you absolutely have the right to ask for subpoena power, and it's an automatic thing. But because we're not attorneys, most people don't know. And I just learned this within the last 30 days. It's a very powerful tool. Okay. Um, and along with the power of subpoena, discovery, y'all do not skip the discovery phase of your case.
Facts.
Meaning, whenever before your trial, you have every right to receive all of the evidence that the other side is using against you, and if they don't turn that over, they're in violations of due process, particularly the Brady law, the Brady case. Y'all write that down. The Brady case is something powerful y'all can use to get them to turn over discovery. And if they don't, then you file your motion to compel. But I've had to use that too, and it's very powerful. It give y'all everything that you guys are entitled to, even though they have not given it to you, including I'm fighting a speeding ticket too, y'all. I'm about to subpoena the records from the district attorney's office that they're using against me, and they're trying to railroad me in the traffic ticket court case because they're trying to make me pick a court date without allowing me the discovery phase. You even have the right to have discovery in your traffic ticket case, including any footage,
Absolutely.
video, everything. So never skip your discovery phase, y'all. Use that subpoena power to get everything y'all want, including those mortgage notes and accounting from the bank and everything. Use the subpoena power. That's our power right there.
That's called equity. That's all.
Thank
All right.
That's exactly what it is. It's equity. That's why it's law and equity in court. Yes, law is there, but equity means that you have the right to face your accuser. You have the right to know the nature and the cause of the action itself. You have the right to see all evidence, etc., that's going to be used against you. Now you have a right to it. See, you can have a right to do something. You got a right to get up and stop listening to me and get off here. That's up to you to exercise that right. Now, if you don't exercise that right, then that means that you are waiving to exercise that right, and you choose to be here. You choose to allow this to happen. You choose not to ask for the things that you have the right to see. So it's all a choice. You have to raise your own issues and defenses regardless. But when you do that motion to vacate based on this situation, they have to have a hearing based upon that regardless. So you can send them a judicial notice and remind them of that they need to grant or deny whatever, have a hearing, but they can't just not answer and say anything, right? They have to do that. And like I said, from that point, I even what a couple weeks ago we had somebody give a testimony about that they just they sat there, and so they did a writ of mandamus to the higher court and mandated them to answer and have a hearing on that motion, and they did. Whether they granted or deny it, it doesn't really matter. You want them to move, and then that still opens up the case. So if they deny it on the motion to vacate, now you can appeal it based upon that particular reason of why you wanted it to be, and that means that they have to hear it.
Thank you. Thank you.
All right, so all right, so with that being said, Got a few more chapters up on the declaratory judgment that we're going to fix up, but today is homework day.
Hey, Eric.
How many of y'all did y'all motions? What's up, JK? Go ahead, bro. You good? Hey, bro. You good? We don't hear you if you think you're talking to us, though.
Hey, I'm on a little delay. Sorry, I'm on my phone, but just relative to Heather's case. Anybody else on a? Oh, I think I'm delayed. Hang on one second. Let me switch to my phone.
All right, you good. We can hear you, though. While he's doing that, y'all got your homework? They don't got their homework.
Was this for the eviction to have a dismissal or something like that?
a motion
Service
to
of process.
dismiss for improper service.
Improper service.
Yeah, y'all got y'all homework.
Slightly.
Slightly. Y'all, I gave y'all a week now.
Nah, I got a little something.
Who got it? We got to hear from somebody today. Somebody got to bring. One person got to bring it up today. And you know how to share your screen? We'll let you share the screen, read it out loud, whatever you need to do. We're gonna let you do what you need to do. But I don't know about. I might share the screen. Some of y'all might have a weird desktop. Some naked people on it. I just had to think about that. You never know. People, people are people. You never know what you might run into on somebody's desktop. So we're going to be careful. We ain't going to share no screen. We'll let you read it. What you got for us? Anybody got theirs? If y'all ain't got it, y'all got this. You got till Wednesday.
What was the homework again?
Yeah, can you say it one more time?
Yeah, y'all on punishment. I'm not telling
I
y'all.
got mine. I got
trying to pull
got
mine
mine,
up.
bro. I just did. I got to change it from like I told you I had did it on behalf of the trust. I need to change it to my legal name, but I got
Yeah, yours is needed for court, so you got to have yours.
yeah for sure.
All right. All right, y'all, this y'all last time. Now, it's about improper service. You need to be able to dismiss the case for improper service. All right? I need to be able to see that and that you know how to do that. And I want you to do it according to the rules and procedure of the state that you in and the rules of that court. All right?
Okay. So look, we're gonna motion to dismiss for lack of improper service.
Hold on. I want it top to bottom. The court,
All right.
you can make up a party. I don't care. Just give it to us in elements of a case.
Okay. All right. I'm gonna say we're gonna move for dismissal for failure to serve the defendant or so-called defendant. Um, they allege that they served the correct party. I want to say June 28th, 2025. We don't have no records of that. As far as I was reading inside the what is it? The case notes. They claim they served a man, a black man, but that was never identified as me in the first place anyway. So
You
we're gonna
you
move for
gonna put
dismissal.
all that in a motion?
Of course.
Oh man. You finna waste the court's
So
time. The court finna be mad.
they served the wrong party.
Well, that's all we need to know. Well, I don't care about what color you is.
Okay.
That don't matter to us. We don't care. We can't hear. Remember, this blind justice. We can't see nothing. We can only hear. So I can't see your color. I can't see none of that. I can only see procedure, authority, jurisdiction. That's and facts. We can hear facts. You know, those are the only things that we can see. That's where everybody got to get into right there. So what I mean by is this. All right. And I thank you. So let me clarify the rules on what I'm saying. I really want y'all to have it fully written down, written out. I want you to give me the name of the court. So you got to start with the state that you in, the name of the court that you in. I don't care. Y'all choose the court. Don't matter. Think of a situation, yourself as the party and the other party that you may involved. And then I want you to literally do a motion to dismiss for improper service. And that means that you are now challenging a certain jurisdiction. I'm not going to tell y'all what jurisdiction it is, but you challenging that jurisdiction. And I need you to properly challenge that jurisdiction. That's what I want to see Wednesday. That's all we going to do Wednesday is we going to hear from y'all and everybody that come in here. I'm looking for your participation. That's why I'm allowing y'all to still kick it in here with me. All 29, 28, 27 people, how many of them? That's what I need from y'all. Can y'all do that?
Cool.
Sure, for sure.
Yeah, we'll be ready, prepared.
I'm for real. Now make sure
Can I
y'all
read
ready.
mine out real quick?
You want to do yours right now? You say you ready right now.
Yep.
Oh, she muscled up on y'all. Go ahead.
Civil Court of the City of New York, County of the Bronx, Housing Court, Housing Park, etc. Index number. The petitioner is Magenta LLC. I'm the respondent. This is the answer to a non-payment petition. 1, general denial. I deny the allegations in the petition. 2, affirmative defenses, improper service, request for traverse hearing, incorrect rent amount discrepancy, public assistance miscalculation, payments not credited, defective rent demand, breach of warranty of habitability, failure to maintain premises, retaliatory eviction, request for repairs and inspection, relief requested, dismiss case, reduce rent claimed, order repairs, and grant other relief. Affidavit of improper service, Ashikima Rosario State. I was not properly served with court papers. Papers were affixed to my door, snail and mail. I am generally home and no attempt was made to serve me personally. No adult of suitable age was served, only minor was served in quotations. I put only minor children reside in the home, and I did not receive any copies by mail. I request dismissal or a transverse hearing.
All right. So the dismissal, and you're challenging for them to show proof of proper service.
Mm-hmm.
So
I
we're
think I
going.
added too much in there.
So we're going to give them a day or a certain time to show proof of that particular service according to the court and procedure itself. Now, everything else that you stated and asked for, as far as in relief, if there's no proper service, then this case does not exist, which means there is really
nothing else. I put too much extra.
It's nothing here.
Service.
So it doesn't mean that you can't do a counterclaim for failure to, for them not having authority to bring the claim. Now you can do that. You can issue a counterclaim and then ask for that relief. But I can't give you that relief just through a motion of dismissal based upon improper service.
Yes. I actually merged two instead of making it separate. I got you.
So, yeah. So that would definitely go into a counterclaim. But that's pretty good. Pretty good.
Thank you very much.
Cool.
Pretty good. All right. So the rest of y'all, I want to see y'all Wednesday, 6 p.m. Central Time. I want to hear it. I want to hear what y'all got. And it's okay. Don't feel bad because it's not whatever. Like, this what we're doing this for. So ain't nobody shaming. Ain't nobody doing nothing because remember, we didn't go to school for this. But we here in God We Trust Academy, learning on the Lawman on the Lawman podcast, right? So let's do that, and let's make sure that we continue to make ourselves better because this is what it takes to study and practice of that daily. All right? So do y'all best. Make sure that it's formed properly, etc. Do the best that you can. And, when you're done, be proud of that. that you made an attempt to do something that you feel like that you might have would have needed a lawyer to do, but you're going to be able to do it today. And just something this simple, guys, you never know. You might run into a situation, and this is a tool that you need to understand that you know that you weren't properly served. If you don't know nothing else, you know you weren't properly served, and you're going to know how to dismiss a case by knowing for a fact that you was not properly served. That's going to feel good. That's a great step. All right. So, with that being said, and I like the affirmative defense that you placed in there. That's pretty dope. But with that being said, guys, that is going to take the time of this class today and Wednesday. We're going to come back in here and we're going to finish up the declaratory ebook. And then we're going to jump right into y'all motion to dismiss as well. Sounds like a plan?
Can't wait.
All right.
Word.
Definitely.
Saturday,
Thank you.
Tuesday, don't forget to see you guys in the In God We Trust Academy group. Are we still on volume 3 or are we going to volume 4? Did we finish volume 3? I think we got to finish 3.
4. I thought we were heading to 4.
Okay.
I don't know if we finished 3.
All right. It's supposed to be 4. Or either way it go, we're gonna find out. I'll go back and look and see and read. And then also, if y'all see a video that we have up in the group, if you see or recognize it has went away, let me know so I can post it back up. Again, they only stay up 30 days when you do live recordings. Only stay up 30 days. So just for me to say that. So I have to still download those and upload those again. So, and all the time I don't be in the group looking for a video. All right. So I just want to appreciate it. Appreciate you guys. And then, know this all love. Everybody continue to keep doing what you are doing and reach the highness of yourself. Remember, stay grounded, stay studying. Remember to read Joshua 1:8 every day and read Hosea 4:6. Read those two. Seriously. All right. Y'all have a great one. Peace, love, and law. We out of here.